a case like that is so monumental.
That's part of Intro to Criminal Law.
I got arrested and they didn't read me my rights. Is my case going to get dismissed?
Which is, it kind of seems like that's what you would want if you're the defense, to try to overturn it.
What does it mean to, one, be in custody, and two, be subject to questioning?
What is the analysis there? When are those rights actually violated? And what does that actually mean?
Okay, so here we are again. It's the end of August, wrapping things up, moving on to, I guess, heading towards the fall. We talked a little bit last time about how hot it was. Newsflash, it's still hot in Arizona, but it's getting a little bit better.
A little better. In fact, we did a field trip for this case yesterday.
That's true.
Yesterday evening. I guess I should say what case we're doing.
Well, this is probably one of the most famous cases in the United States.
Yeah, criminal or otherwise, maybe. Yeah, I mean, almost everybody knows this case as far as by name.
And any non-lawyer, if you say the name of this case, they're going to say, oh yeah, I know something about that. But people usually don't know very much.
And there's some misconceptions.
There's some misconceptions.
Yeah.
There's some untold history, I think, that people don't always understand. And so we're going to dig into that.
And interesting, too, that it has nationwide implications. Eventually went to the U.S. Supreme Court, so it affected the law in every state in America.
Right.
It started right here in Mesa, Arizona.
Right. And the case that we're talking about is Miranda versus Arizona. And so deep historical impact in Arizona, because Ernesto Miranda was a historical figure. He's born and raised in Mesa, Arizona. We're broadcasting to you from Mesa, Arizona. And what Ryan was talking about yesterday, our little field trip, we decided to go and visit the gravesite of one Ernesto Miranda, which, little trivia, he's buried here at the Mesa City Cemetery. We had to walk around just a little bit to find his headstone, but we found it. In the video, we'll throw up a little picture of what that looks like. But a fellow who was born in 1941 in Mesa, died in 1976, went through the criminal justice system, and his case, along with a few others, the Miranda versus Arizona decision was actually a consolidated appeal with 3 other cases, but one that in a lot of ways changed the landscape.
I mean, you go to law school, everybody reads the Miranda case. Right? That's part of Intro to Criminal Law, is you got to go through, what does the Miranda case stand for? What has it changed? How does it work?
And it's one of those few cases where you don't need to go to law school to know what it is, right? Everybody knows their Miranda rights, okay?
That's where that comes from.
And that's where this comes from. And so we're going to dig into, well, how did this all get started? Who was Ernesto Miranda? What was he charged with? Why did his case end up in front of the United States Supreme Court? Now, up to this point, we've only dealt with cases that have kind of hit the ceiling at either the Arizona Court of Appeals or the Arizona Supreme Court. Here, this one went all the way to Washington, D.C. in 1963 and forever changed the way that police have to conduct their interrogations.
Yeah, and investigations. I mean, it changes the entire investigation in a lot of ways. And it's also unique compared to the other cases we've done so far. This is the first non-homicide case, but it's just so significant. Still a very serious case as far as the accusations and the trial, and still an interesting trial process to talk about.
Yeah, so let's roll back the clock a little bit. Let's talk about who Miranda was. We said that he was born here in Mesa, Arizona in 1941.
Troubled kid.
Kind of a troubled kid. I think his mom died early on. He was raised by his father, got into trouble as a juvenile, and then into adulthood.
Even spent a year in custody as a juvenile. That's pretty serious.
Right. It was at the Arizona State Industrial School for Boys, kind of like a boarding school or a...
So I guess that's correct. I shouldn't say in custody,
Mm-hmm.
sort of reform custody in a reform school. That was his sentence, was to go to this school as part of a criminal prosecution.
Yeah, as an 8th grader, later convicted of burglary, sentenced to that reform school, and then released. He relocated to L.A. for a little bit of time. And then, while in California,
immediately gets arrested.
Right, arrested for potentially robbery, sex offense, spent 2.5 years in custody. ultimately extradited to Arizona. And so spent some time in Texas and in Nashville, Tennessee.
Picked up charges in
kind of charges. This guy was in trouble a lot. Okay, so then in 1963, do you want to go into the little bit of facts about this case?
You can kind of fill in some of the blanks for me on this, but basically I know that it was a kidnapping and rape that he was accused of. It appears that the way he was caught really was that a family member or somebody of the victim in the case saw a vehicle there at the time, wrote down the plate number, it came back to Mr. Miranda.
Right, and the ultimate crime was essentially the kidnap and abduction of a young woman. She was leaving a place at night. He takes her, forces her into his vehicle, takes her on a little drive. At knife point, sexually assaults her. I think it's important to really help our listeners understand exactly what happened in Miranda. I think too many times we gloss over, or people gloss over, the facts of what actually occurred. And so what I want to do is talk about the facts as they were presented at the trial level, which is really what we like to focus on. And this section of facts actually comes straight from the court opinion in the Arizona Supreme Court, the Arizona case of Miranda. Before it hits the U.S. Supreme Court, this is what happened in Miranda. And I'll just read directly from the opinion. The facts, as they relate to the defense as charged under counts 1 and 2 in the instant case, are as follows. On March 3rd, 1963, the complaining witness, a girl 18 years of age, had been working in the concession stand at the Paramount Theater in downtown Phoenix and had taken the bus to 7th Street and Marlette. After getting off the bus, she started to walk toward her home. She observed a car, which afterwards proved to be the defendants, which had been parked behind the ballet school on Marlette. The car pulled out of the lot and came so close to her that she had to jump back to prevent being hit. It then parked across from some apartments in the same block. Defendant then left his car, walked towards her, grabbed her. He told her not to scream, that he would not hurt her. He held her hands behind her back, put a hand over her mouth, and pulled her toward the car. He put her in the back seat, tied her hands and feet, and put a sharp thing to her neck and said to her, "Feel this." She stated it all happened so suddenly that she did not have time to do anything. Defendant was unknown to the complaining witness. She had not seen him before, and he was not related to her in any way. He then drove the car for about 20 minutes, during which time the complaining witness was lying in the back seat crying. When defendant stopped the car, he came to the back seat, untied her hands and feet. He told her to pull off her clothes. She said no, whereupon he started to remove them. She tried to push away from him, but he proceeded to remove her clothing, and then, after one unsuccessful attempt, made a successful sexual penetration while she pushed with her hands and was screaming. She testified as follows: "I was pushing against him with my hands. I kept screaming. I was trying to get away, but he was a lot stronger than I was, and I couldn't do anything." He then drove her to 12th Street and Rose Lane, during which time she dressed. She ran home, told her family, who called the police. Her sister testified that the complaining witness came home that morning crying and looking as if she had been in a fight. On March 13th, 1963, this would have been about 10 days later, defendant was apprehended by police. The officers who picked him up both testified that he was put into a lineup and was identified by the complaining witness. Thereafter, he confessed that he had forced the complaining witness into the car, drove away with her, and raped her. After these statements, he signed a statement, partly typed and partly in his own handwriting, which was substantially to the same effect as the testimony of the officers. Defendant offered no evidence in his defense at trial. And then he goes up later on arguing that confession was involuntary. And then that, of course, becomes the subject of the entire Miranda case and everything that flows from it. He's arrested really on suspicion of that offense and another offense based on a license plate that was apparently a description that was given. And he's arrested. He's taken into custody. This young woman then is shown a lineup, a physical lineup. Now, we've talked in the past about these photo lineups that police do. There'll be 6 photos, and the suspect will be in in one of the 6 photos. But this was actually a physical lineup. And they had him speak as well in that lineup.
So that means they're actually there, right? That's like the ones that you've seen on TV where the victim is behind,
Yeah, kind of a Law and Order situation. It seems like that they do that all the time, but
so it's actually pretty rare,
right?
At least now.
In all the years I've been doing this, I've never seen an in-person lineup. In a real case.
It's tough.
Phoenix police, they don't really do it. But back in the day, back in '63, he was arrested, and again, this victim was shown this lineup, and she picked him out, and then they put him in an interrogation room, and if I'm not mistaken, it was at the 620 West Washington Police Headquarters that's still there in downtown Phoenix. If any of you have been in downtown Phoenix at 620 West Washington, it's big Phoenix Police Headquarters. On the second floor is where their detectives are. I've been up to that floor many times. They have these interview rooms, and they look like any other interview room. They're very isolated, small rooms. They've got a little table. The suspect is shackled to the table. Now, if those rooms look the same as they did, however many years ago, 75 years ago, or whatever that was, I don't know. In the last 20 years, I've been up there several times, and that's or a similar location as where Miranda was held. And police spent some time with him, talking with him, and eventually he confesses. Now, understand that the law at the time was that there was no bright line rule where police had to read somebody their rights. I mean, there were no Miranda rights at that point, right? I mean, Miranda is in custody.
Yeah, like we kind of take it for granted that that's just part of the arrest and interrogation process.
Right.
Yeah, but it was not. And obviously that becomes kind of the crux of this case. I wasn't sure if you were, as far as reading through this, of whether she actually did pick him out of the lineup, because the way it was worded at the piece that I read said that they suggested, or they intimated that she had picked him out of a lineup. So then they continue the interrogation, and he's under that impression that he's been picked. And then they say, now we want a voice sample, and it was just her and him. Not face to face necessarily, but he does the voice. They have him say a particular line, and she says, "Yes, that's the voice," which is also an interesting identifier.
Yeah, she did pick him out of the lineup, and then you're right, the voice exemplar was done a little bit later. But yeah, so she was able to ID him as the guy, and as the interrogation went on, he ultimately did make admissions to the detective about his involvement in this act.
And this isn't one of those cases, you see some cases where you do research and you find out about false confessions, and you hear about these officers that just, interrogate somebody for 12 hours and suggest to them what to say. This isn't necessarily one of those cases where it appears that it was incredibly difficult as far as that goes, but because it's interesting, right? You read, he actually did a written confession. He didn't just confess.
Right. So this confession was done in 2 parts. So initially he says, yes, I was involved in it. And then they have him fill out, part of it is typed written that the police filled out, part of it is stuff that he wrote, essentially a written confession. And what's really interesting is the confession says, this statement has been made voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding that any statement that I make can and will be used against me.
I mean, isn't that fascinating? Because we see this case as an example, right? And I don't want to get too deep into this, but many times when a defense attorney or the state is going to appeal a particular case, they want it to be really obvious, right? Like they want it to be, this was one where it was terribly abusive or whatever. Right. You would think that would be a pretty clear statement to the court, to the higher court, to say, look, this was not an overly coercive interrogation, it kind of seems like that's what you would want if you're the defense, to try to overturn it.
And I think what you're saying is you want to pick the right case for an appeal, because if you're going to be making law on an appellate level, you want to do it with good facts that help your issue. And this is one, I agree, in many ways, on its face, it looks like police did a pretty good job of, they didn't force him, they didn't threaten him, they didn't coerce him, they didn't, do anything that was really egregious. The interrogation that they did wasn't particularly long. It was a couple of hours, and they had him sign this confession that says, "I've been fully informed of my rights." Okay, so then we stand back and we say, well, okay, how on earth then did this get all the way up to the U.S. Supreme Court? There's a lot of meat there to talk about, but let's focus on the trial. Okay, so he makes this confession. His case then goes to trial here in Maricopa County. A jury hears the facts, the victim testifies, and ultimately he's convicted.
And his confession is admitted.
His confession is admitted into evidence. He's sentenced to 20 to 30 years in prison in Arizona. And then the appellate work begins. Now, understand that in this period of American history, you have almost a bit of a revolution in terms of criminal procedure. A lot of big landmark cases are making their way through the U.S. Supreme Court, and really solidifying and locking down many of the important protections that are in the Bill of Rights. For instance, the right to counsel, the right to a speedy trial, the right to not have your confession be taken involuntarily. And that's really what this focuses on, is under the U.S. Constitution, we have a Fifth Amendment right against being compelled to make any statements against ourselves, right? And so that is, the cornerstone of what Miranda is all about, is this idea to protect the accused from being a witness against himself or herself involuntarily, okay?
And then the second piece, right, really, and I don't think it's as much of a focus, that's, I think, the Escobedo part of it, but is the Sixth Amendment as far as the right to counsel, to say
That's right.
You have a right to have an attorney if you're going to be questioned for a crime.
Yeah, and so it's this sort of convergence of the Fifth Amendment and Sixth Amendment. Although those are two distinct concepts and bundles of rights, in this area they do converge, right? Because you're a suspect in custody and you have the right to counsel, you have the right to silence. And it's interesting in the Miranda opinion. So he goes to the Arizona Supreme Court first, okay? His case makes it up to the Arizona Supreme Court, and the Arizona Supreme Court affirms that conviction.
They say nothing wrong with it.
He raises a number of legal issues, one of which is this confession issue, and the Arizona Supreme Court says, yeah, that's fine.
And in the end, I guess the objection is the confession should not have been used as evidence in trial because it was, the theory was it was taken in violation of the Fourth Amendment and Fifth Amendment.
Not Fourth Amendment, Fifth Amendment.
I'm sorry, Fifth Amendment and Sixth Amendment.
Fourth Amendment, just for clarification, is right against, among other things, searches and seizures. And so Fifth Amendment is really the focus. So it's interesting, the Arizona Supreme Court again affirms the conviction because under the existing law at the time, and the preeminent case at that moment was another Supreme Court opinion called Escobedo v. Illinois. Without getting into too many details there, essentially Escobedo didn't require a full, what we now call a Miranda warning. And so the U.S. Supreme Court, seeking to clarify some of the difficulties of applying Escobedo to the police work, now look to establish really a bright line rule for what police officers have to do. And to understand this, you have to know that prior to Miranda, there was no requirement that you be read your rights. Okay, you have the right to remain silent, but leading up to that, it didn't have to be told to you.
Yeah, it wasn't the police's job to make sure you were aware of your rights before you waived them or gave them up by speaking, even if it was in violation or, incriminating yourself, or if it was having this interview without, an attorney present. It wasn't their job to say, look, before we do this, you need to understand you have these rights.
Right. And the Escobedo v. Illinois opinion tended toward that direction. The court had this sort of cumbersome test that had to be applied by law enforcement. Are they the subject of the investigation and so forth? And if so, do they need to be advised of certain things and whatever? And it was really unclear. And so in Miranda, along with 3 other cases who were in similar circumstances, these cases are now consolidated in front of the U.S. Supreme Court. And in their Miranda opinion, the Supreme Court spends 20 pages kind of outlining all of this history leading up to this moment in time where they're now going to say, here's what the law is, and here's what it is. Here's what it's going to require.
Right, and that's one of the purposes of the U.S. Supreme Court, is they take a look at a question that maybe is recurring in different states. It's affecting things like, we're going to do our best in the police work, but it might get overturned because we don't really know what the law is to create symmetry between all the states as far, for some areas of law, so that they could do it correctly, but also kind of a clear rule so that they know how to make sure that they're not violating people's rights and how to make sure that these state courts can make the right decisions if, in fact, their rights are violated.
Yeah, and so what's interesting in the Miranda opinion is the court, again, they spend a real long time talking about the history of police work, the history of interrogations and investigations, and talking about how, in the earlier days, it was common for police to engage in sort of brutal tactics and interrogations that took, an infinite amount of time, or that were in such a coercive environment where it essentially forced the suspect to have to confess. And so as a way to sort of remedy that, but then also give a very clear standard for what police have to do, they then invoke this, here's what the law is as it relates to a person's rights, okay? They have to be informed that they have the right to remain silent. They have to be informed that anything that they say can be used against them. They have to be informed that they have the right to an attorney and have that attorney present. And they also have to be told if they can't afford an attorney, that one will be appointed to them.
I think that's really interesting. I mean, you think explicitly at least one of those was used in his little statement. Right?
Well, and that's what's so fascinating about the Miranda facts is he says, with full knowledge of my legal rights, here's my confession, blah, 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 I did it. Okay, but what the court hangs up on is the idea that, was he really told that he had the right to counsel? It really hinged on the idea of right to counsel for him. He knew, and his statement indicated that he understood that he had the right to remain silent, but the Supreme Court honed in on this idea of, well, was he fully informed about his right to counsel? And so again, it's that sort of convergence between the Fifth and Sixth Amendments, but then was he told of that? And the court wanted to create a simple test for law enforcement.
And so how did they create that? What did they do? They created what we have, which are the Miranda warnings. And so you'll see officers many times obviously have it memorized. There are Miranda cards that these officers sometimes will carry around, especially newer officers, and they'll read it out to people.
I'm going to take a little bit of a sidestep there. You're right. Officers are required to read those from a particular card, and they all carry around that card, and it's part of their duty when somebody is in custody and subject to interrogation. We'll come back to that principle, okay? But just by way of a little bit of trivia about Miranda, his case goes up to the U.S. Supreme Court. The U.S. Supreme Court says, here's the new rule that everyone is going to apply, okay? And they reverse his conviction. They say, Mr. Miranda, your conviction is reversed. You're going back down for a new trial. He goes back down for a new trial. He is then tried without his statements.
They keep the
his statement out. Is not admitted into evidence. And guess what happens?
Not guilty, just kidding.
No, he's convicted again.
Yeah.
He's convicted again. What's also interesting is his case had become so famous that they could not try him as Ernesto Miranda. They had to give his case an alias so that they could get a fair jury. The jury didn't know that who they had in front of them was Ernesto Miranda. It was somebody else. So that jury then hears the evidence. He's re-identified and then reconvicted at trial, and then is ordered again to serve that same punishment. But he doesn't serve that long. It was only a few years, and he was paroled. The laws were much different in terms of how much time you had to serve. Today, if you were ordered to serve that, you'd end up serving it.
But he also was in custody almost that whole time.
Right, but it wasn't a 20 to 30-year sentence. I mean, he served several years, and he was released. And my point, he mentioned the Miranda cards. One of the things that Miranda did to make money when he was released,
this is great,
he would autograph the Miranda cards of police officers. And he'd sign it. I think he would make $1.50 or so per signature.
And it wasn't just police officers. He would just have these stacks, is what I heard,
of cards
in his pocket, and just sell them to people who thought it was interesting for him to do that.
I'm Mr. Miranda. Here's my signature. These are my rights.
Yeah,
right. A true champion of civil rights.
So do you want to get into a little bit of what's the misconception out there, and when does Miranda actually apply? Because we have so many people come to us, right? And they're just like, and I don't think it's out of a bad place at all. I think you always need to determine, was Miranda violated, your Miranda rights? What is the analysis there? When are those rights actually violated? And what does that actually mean?
This decision from the U.S. Supreme Court, right, it comes down, it's not decided until 1966 is when they render their opinion. The case happens in 63. After June 13th, 1966 is when the court hands down its opinion. After that, it becomes the law of the land. And as you can imagine, a case like that is so monumental, it's not going to be the end of the discussion. It's really the beginning. And the way the Supreme Court laid it out is when a person is in custody, one, in custody, and two, subject to interrogation, that is when the Miranda rights must be read.
Yeah.
Okay.
And that's where you get it a lot of times. People say, wait, they never read me my rights, and I was arrested. And you say, okay, but did they, take you into custody? Oh, no, they cited me and released me. Oh, okay, did they, you were in custody. Did they ask you any questions? No, they just arrested me.
Right, and so that becomes really the framework for the analysis for the next, even till today. I mean, we see cases all over the country trying to figure out what does it mean to, one, be in custody, and two, be subject to questioning. Okay, what is custody? I mean, you and I could debate custody all day long. Now, we know for a certainty that when a person is under arrest, the handcuffs are put on, they're put in the patrol car, that's custody. There's no doubt.
Obvious.
What if they're sitting on a curb? And what if they're being detained on the curb by a police officer because the police officer is trying to figure out what's going on?
Investigative detention.
Is that custody? There's cases that say, that analyze that and everything in between. What if you voluntarily walk to the police station and you go and you sit down in an interrogation room with a police officer?
And they close the door.
And they close the door, but it's not. Yeah, the door closed. Is it not closed? Is it locked? Is it not locked? Are you free to leave? Are you not free to leave? You can imagine there are a million questions about what is custody. What if they don't put handcuffs on you? What if you're in front of your house?
What if they just stopped you, a traffic stop, and the lights inside, lights are on behind you? Can you, is that
right? What if you're just stopped for speeding? Is that custodial interrogation? How fast were you going, ma'am? Do you need to be read your rights at that point? So you can imagine there is a whole host of cases that deals with each of those questions. And not only that, but what about, what's a question? What if officers arrest you? Okay, you're formally arrested, no question that you're in custody. And what if you're just sitting in the back of that patrol car and they're driving you to the police station and you just start talking? What if they're not asking you questions at all? Do you need to be read your Miranda rights? Okay. What if the two officers are in the front seat making conversation and their conversation is such that it prompts you to feel a little bit guilty about what you've done, and so now you start talking?
Or the question, how much does it have to be aimed at getting some type of information that could be used against you, right? What if the question is just, hey, I'm trying to figure out what happened here. Like you said, let's say clearly they're in custody as far as being in cuffs and in the back of a patrol car,
Mm-hmm.
but the door's not closed. They're not driving yet. And they're just like, look, we're just trying to figure out what happened. What happened?
Okay, I'll do one better. Let's say you are completely booked into custody and they want to know your name and your date of birth and your address and all of those things. Well, those are questions and you're in custody, but it's routine booking information. Can do you have to be read your Miranda rights at that point?
Yeah.
I mean, I don't mean to create so many hypotheticals for people, but you have to understand that every situation is totally different and the law applies completely differently. Now, one of the big questions that we often get is, I got arrested and they didn't read me my rights. Is my case going to get dismissed?
Right. And that's kind of the big one, right? Let's say we clearly have detention, custody. We clearly have incriminating questions being asked, right? And they did not read their rights. And it's shockingly, that still happens. I've had
Totally.
cases.
I'll tell you a story in a few minutes.
Yeah,
Go ahead.
multiple cases where that happened. And so you are able to present that to a prosecutor. They take a look, and do they then immediately say, oh, I guess we messed up, case dismissed? It doesn't mean that. There's different remedies, is what we call it, for different violations of constitutional rights. And this one is not that the case is necessarily dismissed. It's that whatever statements were made in violation of Miranda cannot be used in trial, just like in his trial, right? Ultimately, his confession was found to be in violation of
Miranda rights.
Yeah. And that's a good point, right? It's really not Miranda rights. These are not new rights. They are just a way to make them read you your constitutional rights. But basically, no, it doesn't lead to a dismissal necessarily. It just means that evidence can't be used in trial.
And there's some nuances there, though. Okay, so going back to, the importance of the Miranda rule. If we start with the idea that under the Fifth Amendment, you have a right to remain silent and not to be compelled to be against a witness against yourself, right? You can't be forced to make statements that are incriminatory against you, okay? What Miranda is, it's not really a constitutional rule. It's sort of an extra constitutional rule. It's a rule that forces police to put a layer of protection around your right to remain silent by warning you that you have that right to remain silent. Miranda is not enshrined in the Constitution. It's a judge-made rule that says, in order to protect your right to silence, we're going to tell police that they have to read you these rights when you're in custody and subject to questioning. It's constitutional insofar as it protects a right, but it's not enshrined within the Constitution. Right. Does that make sense?
Yeah.
Okay. I'll tell you a story about a current case that I have. I'll leave out the information, to identify this particular client. But I have a client who was arrested, put into handcuffs, taken into police custody. The first thing they read him his Miranda rights, and he says, I'm not talking, right? He invokes his right to remain silent. Okay. So what happens at that point? Well, and what happened though is, even though he said that, he continued to say things. Police continued to question him. So they violated his Miranda rights insofar as they didn't respect his request to remain silent. Okay. And that too is subject to being suppressed, or meaning it's not allowed to be used in evidence. Okay. Well, Miranda right violations are interesting because in the first instance, yes, the confession or the statement is kept out of evidence. But what if the person goes to trial and testifies now in a way that is inconsistent or contradictory to what they originally told police? Can their previous statement be used against them to impeach them now? And the answer is yes, unless that original statement was done involuntarily. In other words, if they made a statement that was the product of threats or coercion or other things, that can never be used. If police threaten you or somehow force a confession out of you, that can never be used. But if it's a simple Miranda violation, and then you later testify and the state wishes to impeach you with your prior statement, because of that inconsistency, the law says, yeah, it can be used against you.
Yeah.
So there's some nuances here that make it, it's not as, it's not the magic bullet that you would always hope for.
Yeah.
Right.
Now, and the flip side of that is that sometimes it can lead to the dismissal of a case.
Of course.
Right? Because even though it doesn't necessarily lead to dismissal, what if the rest of the evidence is so weak in the case that they really need that confession? Right?
Yeah, it's almost like the inverse of what we talked about a couple weeks ago about corpus delicti, right? So when we talked a little bit about circumstantial cases, what makes a circumstantial case? Well, it's the lack of any direct evidence. If your case is built on sort of weak proof, and then, the capstone to that proof is the subject's confession.
Which is powerful.
Which can be very powerful then, because it cleans up the act, right? It really makes it easier for the state to get their conviction. But if that confession is somehow tainted, then it's thrown out. Sure, I've had cases that have gotten dismissed based on a Miranda violation because the rest of the evidence was no good.
Right.
Or wasn't enough, I
Right.
guess.
Right.
Right?
Yep.
Yeah, so the Miranda case, monumental case, but full of, gray areas where you really need a lawyer to decipher how does it particularly apply in your circumstance.
And it depends on which judge you're in front of. I mean, there's unfortunately they can interpret it differently. You want to talk a little bit about what happened to him after that?
Sure. So Miranda is released from custody, but this guy, it seems like trouble follows him.
Or he follows trouble. It's hard.
Or he follows trouble. I don't know. But, later on, his story is a little bit ironic. After, he's released, he's going back to live, a seemingly normal life. But in 1976 in downtown Phoenix, he's in a bar fight and he gets stabbed. Okay. And, he is taken to Good Samaritan Medical Center downtown. The suspect is identified and arrested. And I don't know how much of this is lore or speculation, but the suspect that they had in custody apparently invoked his right to remain silent.
Yeah, and the accusation was that he wasn't actually the one who stabbed. This is my understanding. It might be different. Like I said, it's been a long time. But wasn't the one who actually stabbed. The allegation is that he handed the knife to the person who stabbed Ernesto, and that when he was questioned, he invoked his Miranda rights and said, I am not going to make any statements. They weren't able to prove it otherwise, and he was never charged. But they did apparently have another suspect that they had strong evidence against as the actual killer, who fled to Mexico, has never been found.
Right, so a little bit of irony there in that, the guy who may have been involved in his stabbing exercised his right to remain silent and wasn't charged. So, I guess a tragic end to really a kind of a tragic figure in that a young man who was, clearly involved in a lot of criminal activity, not a good guy, but whose case really went down in history as probably one of the most important pillars of criminal procedure during that whole Warren Court era of reformation of the criminal procedure in the United States.
Fascinating case, incredibly important. Starts right here.
Starts and ends right here. And I guess that's where we'll wrap up, right? So we had the opportunity, like I mentioned, to go visit his gravesite. Not that we're, enormous fans of Mr. Miranda or anything like that as a person, but I just thought, historically speaking, it's interesting. It's important. He was born here in Mesa. He died in Phoenix, is buried here in Mesa. And I think this will go down as one of the most important cases to come across really our desk and many, many, many other lawyers, right? Miranda has affected that to really an uncalculable degree. So, all right, any other final points?
Nothing from me.
Okay.
Yeah.
All right, good discussion. Thank you.
Thank you.